everybody. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about a very timely topic, the new Family Procedure Rules, Amendment 2, that took effect in April 2024 in England and Wales. And these are really exciting changes because they're focused on trying to promote non-court dispute resolution, NCDR. And the rules define NCDR as methods of resolving a dispute other than through the court process, including but not limited to mediation, arbitration, evaluation by neutral third parties, such as a private FDR process, and collaborative law. Now, I would have loved to see divorce coaching included in there, as the American Bar Association did, but it's still a really big step in the right direction. To help us understand what these changes are exactly and what they mean in practice for divorcing couples, I've invited Liza Gatrell and Matthew Taylor, who are both family solicitors at Stowe Family Law. Liza, Matt, thank you so much for joining us today.
Thank you for having us. Yeah, it's great to be here.
So can we start by the basics, I guess? Could one of you tell us what these changes are in practice? What do they look like?
Yeah, sure. Shall I take that one then, Lisa?
Yeah, you go.
So in practice, this stems from a case that was actually a civil case last year, where the court found for the first time that there was jurisdiction to order parties to mediate, whereas previously non-court dispute resolution, so NCDR, which is a really wordy phrase, but there we go. So NCDR could be encouraged, judicially encouraged, but you couldn't order parties to mediate. And in these civil proceedings, which was a housing case, they said, well, actually, yes, you can go and mediate and stop taking up court time. Then that's been reflected in the family procedure rules, which have followed from that. So essentially, in practical terms, what can now happen is if you start court proceedings and you haven't considered NCDR and haven't embarked on NCDR, you have to justify it to the court. There's a new form that you have to fill in, which says whether it's been proposed, whether people have refused, and if that refusal is reasonable, or if you've embarked on it and it was unsuccessful. And the real practical application of this is that the court can review that, and as part of its case management powers in the family court can say, well, actually, no, you've got to go and try NCDR. You've got to go and try mediation or whatever it may be. Or if alternatively, it might choose not to do that. But if you get to a final hearing, and final hearings in family proceedings are really rare, really, but if it goes all the way to a final hearing, there can be cost sanctions for a party who's found to have unreasonably refused to participate in NCDR. So what it's effectively done is given the court system kind of greater powers to kind of compel. There were some proposals that there was going to be compulsory mediation was going to be introduced, and that wasn't really very popular with a lot of practitioners for various reasons. And this is sort of, I suppose, the next step down, where there are potential sanctions if people don't try and settle their issues outside the court arena.
So the form you mentioned, it is submitted by each individual in the couple as individuals, right? It's not submitted as a couple.
Yeah, that's right. So it's part of your, part of your application process. So you would fill it in as part of your application if you are filing. So in financial proceedings, you start with a form A, and there's a new form where you have to say, here's what's the NCDR we've proposed, they've proposed, it's suitable, it's not suitable, whatever the position is, and you set that out. And then the respondent will obviously be given the chance to kind of set out their version of events as well.
And so why is this such an important shift?
I mean, I think it's a really interesting shift. I think one of the most interesting things about it is the court moving away from just looking at mediation to looking at the whole sort of umbrella of non-court dispute resolution. So I think we have concentrated quite specifically on mediation in the past, and it's not, it's become regular practice that we all know that we have to refer to mediation, or we have to be able to fit into an exemption if a client can't go to mediation. For example, there's domestic abuse within the case, and therefore mediation wouldn't be appropriate. So what's interesting about this is that they are now specifically calling in all of the other types of out of court dispute resolution. So we are looking specifically at things like arbitration, private FDRs, things like that. Why is it so important? I think the reality is the court system is overrun. It's completely overrun. The delays in some courts are horrific, which means that parties that are going through inevitably a difficult time, that time's now been elongated if they're not able to reach an agreement. So I think one of the reasons that this has come about is to effectively keep as much of it as possible out of the court system and try and get it resolved as amicably as possible. That being said, there'll always be cases that simply can't settle for some reason. Either the parties can't agree, or it may be that one party isn't providing the information that they should be to allow that sort of out of court dispute resolution to work. And therefore the court system will be there. But I think that's the intention behind it, I think, is to move as many cases away from the court system, and B, to make people aware of all the different types of out of court dispute resolution, which is a positive.
I guess it shifts as well the priority in that NCDR is considered the default, and then you go to court if that doesn't work. So the approach is different in terms of the message that's being sent to divorcing couples as well, right?
I mean, I think if you are instructing I'm going to call it a good family lawyer, then at your initial meeting, they should be going through with you all of the out of court dispute resolution options available. And that should, my feeling is that the vast majority of family practitioners do that at a first appointment and have done for a good number of years. And actually, we've been doing, arbitration and private FDRs and things like that. Those are things that we've been suggesting to clients now for a good few years, again, perhaps depending on where you are in the country and what sort of delays you have with the court system. But I wouldn't say that there are many family lawyers that just rush off to court previously just to issue proceedings. I think, we've always worked at trying to resolve it as amicably as possible. So this is something that I think the majority of people have been doing. It's the case that I think we're now responsible for showing that to the court, showing to the court what we've been doing if we issue those applications. And I guess it puts a little bit more pressure on perhaps the other party if a suggestion to mediate or arbitrate or collab law, whatever it is put forward. It puts a bit of pressure on them, I suppose, that they have to have a good reason, really, not to proceed with that, because, it could potentially come back to haunt them if they don't try and they do get to a final hearing, as Matt said.
Yes, I think there is a big education piece from the solicitors. I know that I do that with every one of my clients who comes in the beginning of their process. In this new context, whose responsibility is it to educate the public? Because I think that's the piece that's missing here.
I'd agree. Yeah, I think that's a really good point, Chloe. I think that this has been put out there, and if you Google it, if you read around, there's a little bit from the Ministry of Justice. Fundamentally, people are going to find out about this from lawyers. And the people who are going to find out about this from lawyers, generally, so few of our cases end up in court proceedings. They really do, because they're either using one of these formal NCDR processes, or we're using something that may not have a third-party neutral evaluator of some description. But it's me against, the solicitors representing the other party, sorting it out between ourselves. So most stuff stays outside of court. So if you're coming to a lawyer, we have said previously, here are your options. You've got these sorts of 5 options. Court should be normally a last resort. That's normally what happens. Is our advice going to change because of that? Not hugely. We'll say that now the court can compel it if you don't do it. So you can't just say, well, oh, my wife's never going to cooperate, so therefore we'll issue. Say, well, there's potential. You can do that if you want, but there's potential consequences. So I guess it strengthens it a bit. I think where the court system is so busy, and I think part of this is about the court system trying to reduce the pressure on it. And a lot of it is, there is a bit here, and I have some concerns, because all these do cost is what the state is doing is putting the cost of resolving disputes onto individuals to resolve their own disputes, rather than carrying the cost themselves. Now, I'm sure we've all got our own sort of political view as to what the appropriate line is, and we don't need to get into that. But that's a big motivating factor. So the people who this is really going to affect, I think, is litigants in person. Litigants in person who can't afford maybe to pay for a lawyer, or just doesn't want to, they're not going to find out about this. So they will still issue the proceedings. And they won't know NCDR because they've not had it explained to them. And I think those are the cases where a judge is going to get hold of this and say, you've got 2 litigants in person dealing with, let's say it's a fairly straightforward children dispute. There's no big welfare concerns. It's maybe nights of contact, that sort of stuff, which there are a lot at in the system, which are frequently capable of settling through mediation and stuff like that. I think those are the cases where they're going to be given the push, because I think in the vast majority of cases, if you've gone to the lawyer, you've had the advice. Now, not everyone's going to follow that advice and still going to issue, and there will doubtless be some judgments in 12 months' time of people who haven't engaged in NCDR, and then they get hammered on costs. But I think that's a real problem in that a lot of the target audience for this, are they receiving the messages about what it's about? And there's probably a bit of preaching to the converted if it's lawyers who have to tell people who they would tell anyway. Yeah,
absolutely. And Lisa touched upon a subject that's quite interesting around dismissal of NCDR options on the basis of abuse. And I don't know if that's addressed directly in the rules, but is that, I know there's a lot of debate about whether mediation, for example, is an option when there's abuse. Is that something that is officially, excluded from these rules, or are all cases expected to submit the form and consider NCDR?
There's a greater expectation. It will be, if you have a I don't really like phrasing things in this way, but a serious abuse case, because obviously abuse is on the spectrum. And there are some abuse cases that have always been suitable for mediation. That might be shuttle mediation. It might be online. Arbitration and private financial dispute resolution hearings. And I suppose slight tangent at this point, I would differentiate. One of my slight issues with this is talking about NCDR as a whole is difficult, because mediation is so fundamentally very different to the other processes. Arbitration and PFDRs, that is the court process paid for privately. They're great. They're great in the right cases, but they're not, they are still adversarial. It's still court proceedings. There's still a judge. You're just paying for the judge. You're getting an indication. Mediation is so very different to that. It's a completely different approach. So there's always been cases where some abuse cases are suitable for that. There's been a removal from the family procedure rules, some of the exemptions in the old MIAM certificate, which was the mediation information and assessment meeting. We love the wordy acronyms. And that's been watered down a little bit, because there's an acknowledgement that actually mediation, as it's progressed and as the skills develop and the practice develops, because it's still not, compared to court proceedings, it's a sort of a younger creature in our system. That perhaps that's been, in certain cases, it can be more suitable for abuse cases than has been thought. But if you have a case where there is, extensive domestic abuse, really serious concerns about the parties, welfare concerns, it will be for judicial discretion, which can go well and can go badly, as we all know. But that you will be able to argue to a judge, my client cannot enter into an NCDR because here is the history of domestic abuse.
Yeah, I think they're just going to want to know more, aren't they? They're going to want to dig into it in a lot more detail. I think what you said there was completely right, Matt. And also, mediation has come along so much in the last sort of 10 years. Previously it was very much both parties and one mediator sat around a table together. And then COVID hit, and suddenly we're doing mediations online. And then, we've got shuttle mediations where you can sit in separate rooms. And now we've got hybrid mediation where you can attend mediation with your lawyers. And therefore, there are additional layers and additional protections, if you like, for people that are going through abuse that can be put into place. And therefore, it's not the case. I guess the courts now feel that it's not the case that it should just be, if there's any domestic abuse, mediation isn't applicable. It's a much more of a grey area that needs to be considered on a case-for-case basis.
But you wouldn't want to find yourself in a situation where victims of abuse, it's being held against them because they don't, they're told that mediation won't work in their situation, and then it's being held against them because they're the ones who aren't, ready to go through with it. So
absolutely.
It can be a double-edged sword.
It can be, and I'm sure that is one of the things that does cause me a little bit concerned about this. I feel that there will be abuse victims, there will be alleged perpetrators of abuse who are saying to the alleged victims, I'm going to go with alleged in this, and because we're at the start of proceedings and nothing's proven, that's the way we work. There will be people saying, no, we can do NCDR. This is nonsense. Oh, you're making these allegations to just because you want to drag me through court. That's one of my concerns. Is there is a risk that abuse victims are getting sort of hammered with, and obviously the legal burden of proof is on them to prove that what has happened on the balance of probabilities anyway. But it puts them further under the microscope. One of my slight concerns about this format is what I think we will see is lawyers. There will be quite a competitive rush for a first letter where you are trying to say, we will do NCDR, And if you don't do NCDR, you need to explain why. And if you don't do it, then we will seek our costs. Now, you may do that even if your client knows that NCDR is absolutely not appropriate, because there is, it's litigation of some sort, and there is about, trying to achieve the best result for your client. So I think we'll see a flurry of kind of competitive first letters when we do. So I do a little bit of civil work. So under Talata proceedings for cohabitants, your first letter, your letter before action that claim, has always got to set out that you want to enter into ADR. And you do that tactically as much as a willingness to do it. So some cases, the parties have got no intention of doing it, and they've got, but you say it tactically, and you tell your client, you are saying this because if you don't, it will be done on, you will get done on costs. So, I think there is a risk that domestic abuse victims get caught up in that pressure to have to do NCDR because they are being told, well, if you don't, you might get stung on costs later, and they'll end up in an environment that's unsuitable for them. So it will be, I think it's something that practitioners got to be really careful about doing. Got to try and be really respectful, try not to get rushed into that kind of competitive positional stance, and step back and remember, look, we're representing humans, we're representing people, what is appropriate and what isn't appropriate here.
Yeah, and I guess from the judge's perspective, they will need to take these forms with a grain of salt and accept that it's not just a black and white situation. Understand the context behind each person's submission.
Yeah, of course. And they will see the forms, and they will see, as with any initial application, if you make an initial application in Children Act proceedings and you are saying that there is a risk of harm, you fill out a C1A form, which includes your allegations of harm. At that stage, there are allegations. The judge doesn't look at them and read them and go, well, that's happened. There's a chance to respond, and that's the way the court system works, and they're either found or not found. So the judge is going to, these judges are incredibly experienced, long in the tooth. They know that just because it's on the form doesn't mean it's true, but judges will come back to those forms at the end of proceedings. And if someone has put something on there which then proves to be untrue, or proves to be that they kind of come to a finding that the person was just objecting and just being difficult, that's when people are going to get in trouble.
Yeah, that's a good point. So do these changes impact at all the role of the solicitor in the divorce proceedings?
I don't think so. I don't think it's going to massively change the role of a lawyer, other than the points we've kind of hit on, as far as, those initial letters potentially being slightly different. I mean, I really do think that the majority of the lawyers are going through these things with their clients anyway. This is something that we are doing day in, day out, and have been for a good number of years now. So I don't think it's a new beast, if you like, that's kind of come out and we're all suddenly like, oh my goodness, it's a new procedure that we absolutely have to follow. Because ultimately, I think it's something we've all been doing. It's just a case now we've got to fill out an additional form to say why we've chosen to go that way. And I think ultimately, the intention behind this is to remove cases from the court and to resolve things more amicably. But in reality, for certainly the lawyers that I have in my team, we have, of however many cases they've got, less than 20% of those cases are in court. And I would say less than 1% of the ones that are in court go to a final hearing. We are heavily about resolving amicably cases wherever we can. There will always be those cases that have to go to court, because it may be that the other party isn't disclosing information, they won't provide information, whatever it might be, or the parties simply cannot agree. They're at loggerheads and they're miles apart, and no degree of out of court resolution is going to assist with that. But ultimately, my feeling, Matt might not agree, is that day to day, I don't think the advice that we give to clients or the way in which we're working will change massively.
Completely agree. I think that's right. I think, save for that little tactical flurry at the start, which I do think is going to be a consideration, I think that generally, I can only speak for us, our firm, lawyers that I know that I work with and I work with well. And I think generally everyone talks to them. The only cases that exist in that me and my team, so there's sort of 8 of us in the team that I head up. So, and we've each got about 30 cases. So, there's like 240 cases at any given moment. The only cases that go straight to court are those where there is an immediate risk of harm to either a party or a child. And that's still going to have to be the case. If there is, in financial cases, if there is a need for a freezing injunction, someone's dissipating assets and you've got to go urgently, that will still be the case. Or there's a very serious history of domestic abuse and some very serious allegations. So
Yeah.
it's not going to change our approach to, in my team, we've talked about it. We're going to carry on giving the advice that we've given with the extra layering of, look, here is the new thing. The court may say to you, go and mediate if you haven't and you're doing it unreasonably. You know, I can't speak for other lawyers. But maybe other lawyers are rushing off to court a bit more frequently. I'm with Lisa, though. I suspect generally most aren't. So I don't think it hugely changes things. But I think that, coming back to what you were saying before, I think encouraging people to find out more about these other options and find the thing that works best for them is a really positive thing. Is the information piece out there at the moment to go with it? No, but then, you know, every mediator that I know has been trumpeting these, you know, and saying why they're valuable things, and that's great. You know, we've got a blog on our website, Stowe Family Law, talking about it. So the noise is being made by the profession. You've just got to make sure that the people who need to get that message are receiving it. And is that the case? I guess time will tell.
Yeah, and that they understand the cost implications of each option, time implications, etc.
Yeah, completely.
But for those 1% that Lisa mentioned that do end up in a final hearing, do we know how the forms will be used for the judge in making decisions? You mentioned that there would be potentially some bearing of costs for if one person is found to have blocked NCDR options. Are there any other implications that could be coming out of that, even in terms of, you know, splitting matrimonial assets?
I think it's incredibly unlikely to impact the actual splitting of the assets. So if we're looking at financial cases, there are sort of 2 or 3 heads of costs, areas in which the court can make costs. So there's a really great case, if anyone's interested, from last year called OG and AG, which sets out in really, really good detail when courts should or shouldn't be making cost orders. And that makes it really clear, that's by a very senior judge who's now retired, called Mr. Justice Mostyn, makes it very clear that it'd be incredibly rare that litigation misconduct, which is one of the heads of cost, would ever affect the substantive distribution of assets. And a failure to participate in NCDR would be litigation misconduct. You are not following the family procedure rules, therefore you are litigating badly. That will result in you've dealt with your, and it's 50-50, it's 55-45, whatever it is. Done that, done the distribution. Now let's have a look at costs. But what that case also says is most cases are needs cases. Most people are trying to get enough to meet their needs, or both falling just short of their needs. Historically, the family court's been quite resistant to making cost orders that put parties below their needs. But OG and AG and a series of other cases around it have said, well, look, if someone is litigating how they shouldn't and increasing costs from other people, then even if a cost order would put you below your needs and reduce your needs, then we still make a cost order. So I think it's not going to mean that you can argue you should have more of the assets. But once the asset distribution is done, you can say, I have been put to X amount of cost because of the other party's failure to enter into NCDR. Therefore, the other party should pay some of my costs. If that means they can't meet their needs, well, that's on them. And I think the court will be very receptive to those arguments.
Interestingly, it'll be, I've had to spend this money as opposed to what? Because if I had gone to mediation, it might have been a couple thousand. If I did arbitration, it was, you know, way more, £1,000 or £1,000. So on what basis are they going to be able to compare?
I mean, that's a really good point, and it will be interesting to see how the judiciary handles it. It will depend on the scale of the objection. And
so, Lisa, from your perspective, what are the benefits of these new rules to divorcing couples? You mentioned the benefit for the judicial system and trying to declutter the courts. Are there benefits for individuals?
I mean, ultimately, they have to think about it more, and both parties have to think about it more. And certainly, I know that we've been very hot on mediation and referrals to mediation before issuing proceedings, but I know that I've also sent out letters suggesting arbitration and private FDRs in the past, and I hit a brick wall. And I think whereas previously that was fine, you know, they didn't want to do it, that was up. I think now this is going to be a change because they have to say why they don't think that's an appropriate thing to do. And actually, as Matt said, if we're talking about things like arbitration, ultimately we're talking about private court proceedings. So there's no, you know, as far as procedure, etc., there's no massive difference other than you're paying for the judge's time and it's done much quicker. And one of the things that I would say, which I think will be helpful for some people, is I know certainly I've had clients in the past that are perhaps the weaker financial party that do not have the amount of money to throw at legal proceedings and all the rest of it than the other party does. There may be elements of coercive and controlling behaviour and things like that. And in those circumstances, by actually really putting some pressure on to use things like arbitration and private FDRs, it really helps that client to potentially reach a resolution sooner in circumstances where the other party may well have just dragged it all the way out to a final hearing over 18 months under the previous system. Now, the reality is that this is all very new. So we don't know how parties will, it may be that in that circumstance, the party that has the more money says, do you know what? I'd much prefer to still drag it out, and I don't care if I get hit with costs in 18 months' time, and it may make absolutely no difference. And I think that's something we're just going to have to wait and see, I suppose. When these new things come out, we really have to see how they're gonna work in practice. But I think one of the major benefits of this is absolutely just highlighting all the different areas of alternative dispute resolution rather than focusing solely on mediation.
That makes a lot of sense, Lisa. Thank you so much. I absolutely see how there will always be some people who will want to pursue court proceedings to be able to kind of bully the other. But the good thing is that now there's that protection that it can be held against them. You can't compensate someone for the stress and distress you've put them through in doing that, but at least there's some sense of justice in that respect. Thank you both very much for joining me. It's been such an interesting conversation, and I'm looking forward to see how things develop. And once we have a bit of case law to look at, if things pan out differently than anticipated, it'll be interesting to see.
Yeah, absolutely. It's been a really interesting discussion. So thanks very much for having us on for a bit of a chat about NCDR.
Yeah, thank you so much.
Thank you both. Have a great day.
You
Take
too.
care.
Bye.